Court of Appeal adjourns Nnamdi Kanu'S case indefinitely. The Court of Appeal, sitting in Abuja, the Federal Capital Territory of the country, on Tuesday, 13th of September 2022, has reserved judgment on the case against the detained leader of the proscribed indigenous people of Biafra, IPOB, Nnamdi Kanu. Human rights lawyer Mike Ozekome, SAN, who led the delegation of legal practitioners representing the IPOB leader, urged the court to strike out the remaining charges, citing a lack of credibility. The Federal High Court Court of Appeal sitting in Abuja today has adjourned and reserved the judgment on the case against Nnamdi Kanu, who is the leader of the proscribed indigenous people of Biafra. You're welcome to Politics Now, and on the platform we talk about Nigerian politics. We give you updates on the 2023 general election and all you need to know. Kindly subscribe, turn on post notification, and do well to like this content. We all know that the indigenous people of Biafra, IPOB's leader, Nnamdi Kanu, had been in detention for a while now, and his case had been ongoing. And today, which was a sitting at the Federal Court of Appeal, whereby the delegation of legal practitioners representing the IPOB leader urged the court to strike out the remaining charges against the IPOB leader due to lack of credibility. According to Ozekome, specifically, he prayed the appellate court reviewed the April 8th ruling of the trial court, which struck out only 8 out of 15 charges which were leveled against Nnamdi Kanu. As at April 8, 2022, 8 charges were actually struck out against Nnamdi Kanu. Meanwhile, there were 15 charges and 7 were left. According to Ozekome, he prayed that the Court of Appeal review the ruling of the April 8th and thereby, dismiss the remaining 7 charges. He also insisted that the charge the federal government entered against him had no basis in law. Kanu, in his appeal dated April 29, marked CA ABJCR 625 2022, applied to be discharged and acquitted. The counsel representing Nnamdi Kanu had insisted that the charges entered against Nnamdi Kanu by the federal government had no basis according to the law. However, following an application the embattled IPOB leader filed for abridgment of time, the appellate court brought the matter forward for hearing as against the initial October 11 fixed for the hearing. Meanwhile, due to the application that was filed by the IPOB leader for the abridgment of time, the Court of Appeal brought the matter forward. The matter was, supposed to be seated on by October 11, but the Court of Appeal brought it forward to be seated on a month earlier, which was today, 13th of September 2022. According to Nnamdi Kanu, he had applied for the charges to be, discharged and acquitted. When the matter was called up today, a 3-man panel led by Justice Jumai Anatu said it had no need to delve into the issue of bail since the substantive appeal was ripe for hearing. Arguing the appeal claim, Ozekome alleged that his client was forcefully abducted from Kenya and illegally renditioned back to the country. Let's not forget that last year, Nnamdi Kanu had been arrested in Kenya, and according to his lawyer, Ozekome, he alleged that Nnamdi Kanu was forcefully abducted from Kenya and he was illegally brought back to Nigeria. He told the country that his client was first arraigned on December 23, 2015 and was later granted bail on April 25, 2017. According to him, he said, "My lords, he was enjoying his bail without breaching the terms. However, he was in his ancestral home when agents of the respondent invaded his home in September 2017. So according to him, Nnamdi Kanu's home was allegedly invaded in 2017. That was in 2017, September 2017. When the appellant traveled from London to Kenya, agents of the respondent on June 27, 2021 forcefully abducted the appellant, tortured and renditioned him back to the country without following any extradition process, the lawyer added. He further argued that Kenya, being the country from where Kanu was arrested and extraordinarily renditioned back to Nigeria, ought to have authorized his extradition. According to him, there was no authorized extradition from Kenya, which was the country where Nnamdi Kanu had been arrested. Meanwhile, the federal government, through its lawyer, Mr. David Kaswe, urged the court to dismiss the appeal for want of merit. He asserted that the IPOB leader was brought back to the country by due process of the law. He argued that the charge had been amended 7 times owing to the conduct of the appellant. After listening to both sides, the panel said it would communicate a date for the judgment. So the two sides had argued, and according to the counsel of the federal government had wanted the appeal to be cancelled, to be dismissed, due to the fact that Nnamdi Kanu had been brought to Nigeria following the due process, which were legal and also authorized by the Kenyan government. Although the Kenyan government, since Nnamdi Kanu had been extradited to Nigeria, had not said anything about this. I believe that the case has already been adjourned, and also we do not know the fate of Nnamdi Kanu when the court sits the next time. But the judge said the date for the judgment would be communicated very, very soon. Let's just be on the lookout for what is going to happen. Although the United Kingdom has also said that Nnamdi Kanu should be freed and he should be discharged and acquitted with no charges against him anymore, but the case is still ongoing in the court, whereby as at April, the charges against Nnamdi Kanu were 15, whereby 8 were dismissed by the court, although there were 7 charges left, and also his lawyer wanted the 7 charges to be dismissed against him. Let's be on the lookout. So kindly subscribe, turn on post notification, and like this video. Thank you.